Article 5, provisions on appointment of guardian for those continuation of business for those below 21 years of age or those incapacitated have been repealed by the rules of court. So Article 5 has been repealed when it comes to the appointment of guardian for those who are engaging in commerce below 21 years old. Republic Act 6809 has rendered moot the provisions of the Family Code on emancipation of minors with the lowering age of majority to 18 years old. Okay, so the parental authority. Article 6 to 10, provisions on the capacity of wife to enter into commercial transactions and the liability of the husband therefore have been repealed originally by Articles 117 and 163 of the Civil Code, and now the applicable provisions is Article 73 of the Family Code. So therefore, if this Article 6 and Article 10 is already repealed by Article 73 of the Family Code, in which we talk already about Article 73 is consent. Remember the consent in which benefits accrued to the family prior to the objection. So prior to the objection, there is already benefit accrued or being provided to the family. Then therefore, those resulting obligation shall be enforced against the community property. Otherwise, it shall be enforced with the separate property of that spouse who has not obtained consent with the other spouse. Next, Article 11, the married woman over 21 years of age may likewise engage in commerce in any of the following cases. Okay, Article 11. When she lives separate from her husband by reason of final decree of relative divorce. When, number 2, when her husband is absent, his whereabouts being unknown and his return not expected. When her husband is under guardianship. When her husband is serving the penalty of civil interdiction. So civil interdiction is an accessory penalty, cutting the rights of a husband to be a guardian to his children. That's one. So how is that? Article 11, wherein it should be a married woman over 21 years of age. So no need, if that woman is already over 21 years of age, no need for parental authority. May likewise engage in commerce in any of the following. May. So it means to say without the consent of the husband already. So when she lives separate from her husband by reason of final decree divorce, so separated already. When the husband when the husband is absent already or very absent for more than 4 years already, so there is already presumptions of absence. When her husband is under guardianship, so it means to say there is a court order that the husband will be under guardianship and the husband is serving a penalty of civil interdiction, so the rights are deprived. Certain rights are deprived. Article 12. In the cases referred to in the preceding article, only the private property of the wife and that of the community of conjugal partnership acquired through her commercial transactions shall be liable for the results thereof, the wife having the power to alienate and mortgage one or the other. When the absence of the husband is legally declared, the wife shall furthermore have the powers granted to her in such case by the civil law. Again, how is that? In cases referred to in the preceding article. So those preceding preceding article. What is the preceding article? It's the Article 11. It's the Article 11, di ba? Article 11, that's the preceding article of Article 12. In cases referred to the preceding article, only the private property of the wife and that of the community of conjugal private property of the wife and that of the community of conjugal partnership acquired through her commercial transactions. It should be acquired through her commercial transactions shall be liable for the results thereof, the wife having the power to alienate, mortgage one or the other. So only those private property and that of community property, those property contributed to the community property, shall be held liable for the results. What's the results thereof? The death incurred, expenses incurred in engaging business. So those expenses, debts shall be charged against the separate property, against the private property of the wife. When the absence of the husband is legally declared, so what if the husband is already presumed absent? The wife shall furthermore have the powers granted to her in such case by civil law. Under Article 73 of the Family Code, again, Article 73 again, wherein now provides equal provision for the law. Equal provision provides equal provision for the power of the husband and the wife to bind properties of the marriage. Either spouse may exercise any legitimate profession, occupations, business, or activity without the consent of the other, with the other spouse allowed to object on valid, serious, and moral grounds. That is in under Article 73 of the Family Code. In cases of disagreements, the court shall decide whether or not the objection is proper and make rulings on the benefits, depending on whether the benefits had accrued to the family prior to the objection or thereafter. If the benefits, again, this is now to be considered by the court when it comes of this agreement between the parties, between the spouses. If there is benefit provided to the family or accrued means obtained or earned prior to the objection of the other spouse, the resulting obligation shall be enforced against the community property. So it means to say, if there is benefit obtained from that business and the debts and expenses incurred in engaging that business shall be charged or shall be taken from the community property, otherwise to the separate property of that spouse who has not obtained the consent. I keep on repeating. Under Articles 11 and 12, where the married woman engages in trade, if her husband is either under guardianship, has been declared in absentee, or under civil interdiction. So it means to say here in under, and this is now already somewhat an exemption to the Article 73. Article 73 of the Family Code has a limitation. What is that limitation? That can be found in the Articles 11 and 12 of the Code of Commerce, where the married woman engages in trade if her husband is under a guardianship, declared absentee, or civil interdiction. Her parental property shall answer for her obligations, and then that portion of the conjugal property that resulted from her business transactions shall also answer for her debt. So it means to say here, in this situation, in these Articles 11 and 12, because in Article 73, without consent of the husband, spouses are in together under Article 73. They are intact. They are working as one. Both of them are working as one. So that is in under Article 73. What if the husband is already declared as absentee. So in these articles 11 and 12, it is already the married woman alone, because her husband is already under guardianship or declared absentee or under civil interdiction. So whatever debts, expenses incurred in doing business by that married woman, it shall the expenses and debts shall be answered by the separate property, by her parental property, or a portion of that conjugal property. The portion of the conjugal property that resulted from her business transaction shall also answer for her debt. So, in Article 73, the answerable what do you call this? The answerable property only is her separate property if the objection is proper. If the objection is valid, serious, or moral grounds, therefore, those expenses or obligations obtained from the business shall only be taken from her separate property if there is no benefit to the family. But here in Articles 11 and 12, it can be taken from her parental or from her separate property, and a portion can be taken from the conjugal property, provided the husband is under guardianship, declared an absentee, or a civil interdiction. So it means to say, it's good for the woman, for the married woman, because she has the support from her parental and also from conjugal partnership. But in Article 73, she needs to the married woman needs see to it that there is benefit to the family, so that whatever expenses or debts may incur, it may be charged against on the portion of the conjugal property. The absence of the husband contemplated here is the second stage of the absence provided for in the Article 384 of the Civil Code, wherein 2 years having elapsed. 2 years. It should be 2 years elapsed. That is in Article 384 of the Civil Code. 2 years having elapsed without any news about the absentee. Yes. 2 years elapsed from the time of being absent since the receipt of the last news. 5 years in case of absentee has left a person in charge of the administration of his property, his absence may be declared. So that is in under Article 384. These are the conditions wherein 2 years having been elapsed. So from the time the husband disappeared, count 2 years. 2 years. After that 2 years, therefore absent. So again, elapsed without any news about the absentee, or since the receipt of the last news. 5 years in case the absentee has left a person in charge of the administration property. 2 years without news about the absentee. 5 years in case the absentee has left a person in charge of the administration of his property, his absence may be declared. As noted previously, the provisions of Articles 11 and 12 are deemed modified by Article 73 of the Family Code.